We're going to be talking about confidentiality agreements. Now, this is not about restraints of trade, and I've talked about that in a different part of my website. These are about confidentiality in terms of confidential information. Now, what are a confidentiality agreement? Now, this might go beyond what you've been. A confidentiality agreement might go beyond your employment contract. Usually, employment contracts have some sort of confidentiality clause in it, but an agreement will go further. It will outline a lot more information about what is confidential and what isn't. It will dictate what happens next, most likely, and it can be several pages long. So depending on what's going on with your employer, who your employer is, what you're doing with the employer, you may or may not be asked to sign a confidentiality agreement along with your employment contract. And it could be a condition precedent to your employment contract. So that could mean that it could be a requirement for you to be employed with this person, with this organisation, with this company, that you sign this confidentiality agreement as well. One of the questions we get is, I've received a confidentiality agreement from my employer. What do I do? Well, if you've received a confidentiality agreement from your employer and it's before your employment starts, then think carefully about whether you want to comply with the clauses in that confidentiality agreement. Or you've got an employment contract and you want to look at that confidentiality clause. Just be certain that you are able to comply with it, because once you sign the contract, once you sign that agreement, you're agreeing to those conditions. If you want to negotiate with your employer in relation to that confidentiality agreement or clause, then we would encourage you to seek legal assistance to do that. It is really complex area of law, and if you are going to negotiate with your employer, we would recommend that you get legal assistance to get the proper advice about how to negotiate properly. If you've been given a confidentiality agreement after your employment starts, then that is an additional term to your employment agreement or employment that didn't occur at the time of your employment coming into fruition. You becoming employed with this company or business. So signing a confidentiality employment after your employment contract, after your employment starts, is actually a matter for you. So you can choose to sign it or you choose not to sign it. But just remember that if you choose not to sign a confidentiality agreement that's been given to you after your employment starts, then you need to think about what's going to happen with your employment relationship after that. I'm not suggesting that you should sign, and absolutely you have to. All I'm saying is, if you find that you've been adversely treated because you've chosen not to sign, then that might be a matter of a general protections issue. If you've been terminated because you haven't signed, that could be an unfair dismissal, or it could be a general protections matter. Or it could be that your employment with them has become quite strained. Or there could be some other reason for why you have chosen not to sign the agreement and your employer is not okay with that reason. So look, think about the employment relationship. If you're finding that the employment relationship is degrading, for instance, because you haven't signed this agreement, you might want to get some legal assistance with this. First of all, we can tell you by talking to you about the situation as to whether it's something that you might want to do anyway. You know, for instance, you might not want to sign for a particular reason, and after talking to some after getting some legal advice, you might find that reason is not so important to you anymore. Or you might find that reason is more important than ever, and absolutely you're not going to sign. But I think informed consent is actually the important key here. So talking to someone about that and getting informed about what this means to you, giving you more information about whether you should sign or not is probably actually super important at this point. Another question we get is, my employers asked me to sign a confidentiality agreement, but in the agreement they haven't really told me what's confidential. Does it make it invalid? No, it doesn't. It just makes it harder to enforce. Yeah? An invalid confidentiality clause is not just a matter of confidential information not being particularized. There needs to be some other quality to it. It could be invalid for lack of certainty, but it's not going to be just invalid as a matter of fact. It's like the rumour that used to go around that if a policeman's not wearing his hat, he can't give you a ticket. these things aren't real, and there needs to be other reasons in and around the document to make it invalid. A little bit like, if your name is spelt wrong but you sign the document anyway, is it invalid? No, it's just a clerical error that can be rectified quite easily. And the right parties sign the right document, and the right parties witness the right document, so it's just a clerical matter. So no, it doesn't make it invalid, but it could make it invalid depending on the construction of that clause itself, because of the uncertainty issue. I've breached a confidentiality agreement. My employer sent me a letter threatening to sue me for it. How do I deal with this? Well, okay, so breaching confidentiality can be super serious. It goes to the very core of what a business is. It could be that, for instance, if you're working at a law firm and you breach client confidentiality, there could be legal ramifications for that law firm and actually legal ramifications for you. If you're breaching the confidentiality insofar as selling company secrets and in kind of like an espionage type of format, then yeah, you're probably going to find yourself on the wrong end of suing action, depending on what the value is of that information that you've taken. The first thing you need to think about is, what is it that you've done? What does the contract say? What are the implied conditions for confidentiality? And how are you going to move this forward? Is it worth talking to your employer about negotiation, maybe do a deal, pay for some of the information, do a retraction? Or is it just worth being litigated and you follow through the litigation process, you put your defence in, you turn up, you argue your point, and hopefully you win? Really, how you deal with it once it's happened is really a matter for what's going on and your capacity of risk, really. Remember, lawyers cannot guarantee any outcomes on these things. We are not the decision makers in this process. Not being the decision maker means we cannot guarantee the decision. But we certainly can help you get as close to what you need and what you want as possible. If it's a defending and try and lowering the liability, then we can certainly try and do that. And in great extent, we may well be successful. If it's about negotiation, then we can certainly assist you in entering into that negotiation. We're pretty good at negotiations here at MJT Law. And if you needed to negotiate with your employer, depending on what you're asking for, depending on what the employer is asking for, you can get some really good results that way. Thank you for watching.